Okay, I think we will make a start then. So good morning to everybody and welcome to our webinar in which we're going to be looking at some of the key contract cases of 2021. My name is Rowan Turrall and I'm a partner and head of dispute resolution at Boyes Turner, and I'm joined for this session today by Sophie McDonald, who's an associate in my team. We've got 9 cases to run through for you on 8 topics. And we're going to consider some of the lessons that can be learned to avoid you finding yourselves in disputes in the future. So our agenda for today, our topics are 2 cases dealing with battles of the forms, a case dealing with the incorporation of unusual and onerous terms, a tale of a schedule that didn't exist, and a limitation of liability clause. We're then going to look at a cap on liability, an exclusion of liability, liquidated damages, and we're going to finish up with a case concerning common law versus contractual termination rights. If you'd like to ask us any questions, then please do use the Q&A function. And if we don't get the opportunity to answer those questions today, then we will follow up with you afterwards. So over to you, Sophie, to kick us off on the Battle of the Forms.
Thank you, Rowan. For our first case, we're going to start at the beginning of the contractual journey with the Battle of the Forms. This was the case of TRW Limited v Panasonic, which made it to the High Court and then onto the Court of Appeal earlier this year. In January 2020, TRW sued the defendants, alleging that certain resistors supplied by Panasonic were defective. The Panasonic defendants were companies based in Germany, and they applied to set aside service or for a declaration that the English court had no jurisdiction or for a stay. TRW is the English subsidiary of a German parent company. Panasonic argued that the parties had agreed to German law and the jurisdiction of the Hamburg court applying to any claim by TRW arising from the resistors. TRW argued that the parties had agreed to English law and jurisdiction. As with any battle of the form cases, there is some toing and froing that needs to be analysed. The starting point was a customer file document that Panasonic required customers to sign. TRW companies across Europe, including England, signed such documents on various occasions between 1998 and 2019. In this case, TRW had signed a customer file document on the 28th of January 2011. The customer file stated that TRW had received and acknowledged Panasonic's general conditions. You will see that I've set out the first part of the relevant clause in full on the slide. The conditions went on to provide that Hamburg was stipulated as the place of performance and that the jurisdiction and choice of law was German law. There was also the right for Panasonic to file suit at the domicile of the buyer or one of his branches. TRW placed orders under 2 purchase orders in 2015 and 2016, which asked for goods to be delivered in accordance with TRW's conditions of purchase. The 2015 purchase order included the wording, commencement of any work or delivery of any goods or service under this order or delivery schedules or releases shall constitute your confirmation that you are aware of and accept such terms and conditions and requirements. Around the same time, there were price negotiations on a global basis, which confirmed in a letter referring to TRW's terms. You will see that I have set out the wording of the 2016 purchase order on the slide. It also repeated the wording from the 2015 purchase order. The jurisdiction and choice of law clause in the purchase order provided for the laws of the state or country shown in the buyer's address and for submission to the jurisdiction of that country too. This would have resulted in English law and jurisdiction. Panasonic was not asked to sign and return the purchase orders or confirm agreement to TRW's terms. They did deliver the resistors that were subject to the matter of the purchase order. In summary, Panasonic's case was that their terms and conditions were incorporated expressly into a document signed on behalf of TRW, setting out terms that prevented TRW from seeking to incorporate subsequent inconsistent terms by conduct, unless expressly agreed by Panasonic. TRW's terms were never the subject of agreement. TRW's terms were not signed by Panasonic. No document went back from Panasonic to TRW agreeing to TRW's terms in writing. TRW's case was that Panasonic's terms were not set out in a document which had contractual force. They had signed acknowledging receipt of the terms, but did not confirm their agreement would apply to the subsequent sales. TRW fired the last shot by referring to their own terms and conditions in the purchase orders. By delivering the goods, Panasonic accepted incorporation of TRW's terms. In finding in favour of Panasonic, the judge concluded the following. The practice of signing the customer file accompanied by general conditions was a familiar feature between Panasonic and TRW entities in Europe between 1998 and 2019. Signature of the customer file acknowledged the terms and conditions and their applicability to any subsequent supply contract. He rejected the submission that the signature was only acknowledging the existence of the terms and not their applicability. He accepted that the signing of the customer file did not create an obligation to buy or sell Panasonic's products. It placed them under an obligation to do so on Panasonic's terms if they subsequently chose to do so, unless otherwise agreed in writing. Panasonic's conditions protected them from falling victim to the last shot doctrine. The wording conditions of the buyer diverging from our terms and conditions shall not be valid even if we effected delivery or rendered services without reservation was clear and unambiguous. Although it's unusual, the last shot missed the target here. The attempt to impose TRW's terms and conditions through purchase orders failed because it had committed itself to Panasonic's terms and that the divergent terms would be ineffective. The two purchase orders, even though unsigned, could in normal circumstances have acquired contractual force by offer and acceptance, but the judge preferred Panasonic's arguments that their terms could only be overridden with written consent, and that was not given. The judge at first instance therefore set aside the services of the claim and declared that the Hamburg court had exclusive jurisdiction. TRW appealed. Permission to appeal was given by the judge with little enthusiasm on the basis that the Court of Appeal might decide that the last shot did hit the target. In the Court of Appeal, the argument focused on whether Panasonic could demonstrate its terms and conditions applied. If not, then the default position under Article 7 of the recast Brussels regulation was English jurisdiction on the basis that there were goods that were delivered. The Court of Appeal considered the Court of Appeal's judgment in the case of Tech Data Interconnections v. Amphenol in 2009, in which the last shot doctrine prevailed, but the court recognised that it could be displaced by evidence of the parties' objective intention. The Court of Appeal found it unsurprising in this case that the judge had concluded that the signing of the customer file was a key event. It was the only document that was expressly signed by the parties. As Lord Justice Coulson described it, continuing the last shot analogies, it was the only occasion when one side walked across no man's land and fraternised with the enemy. The Court of Appeal agreed with the judge that in the contractual commercial world, one party does not sign a document just to confirm that terms and conditions exist. Lord Justice Coulson drew an analogy between the customer file and a framework agreement or a master contract generally. TRW also tried to raise an argument there was no consideration for the agreement to Panasonic's terms, but as this was not raised before to the judge, it was not allowed to be raised on appeal. In conclusion, the Court of Appeal dismissed the appeal and the first shot continued to hit the target. Our next case is Dana UK Axle v. Frodenberg FST. This was another case in which there were competing sets of terms and conditions which affected the choice of law applicable to the dispute. Here, there was also a one-year limitation period in issue. The dispute related to a contract for the manufacture and supply of pinion seals by FST to Dana, who then fitted them onto a vehicle rear axles for onward supply to Jaguar Land Rover. It was alleged that there had been premature failure of the seals between September 2013 and February 2016. The case dealt with a number of issues, but for today's purposes, we're going to focus solely on the Battle of the Forms. FST's case was that the supply was governed by a contract which was formed on the basis of its terms and conditions in 2003. These terms included a German choice of law clause and a one-year limitation period. Dana argued the 2003 contract was on their terms and was superseded by a 2012 purchase order. During the relevant period, the contract was governed by the 2012 purchase order incorporating the 2011 version of Dana's terms and conditions, which was then superseded by a 2013 purchase order, which also incorporated the 2011 terms and conditions. It was agreed between the parties that the question of the formation of the contract should be decided in accordance with English law. By way of a background, in 2003, FST sent Dana a quotation for a new seal, which stated, "Further to our recent discussions, we are pleased to submit the following in accordance with FST's terms and conditions." FST's terms and conditions were not provided with the quotation. It has not been suggested that they were provided in the course of previous dealings between the parties. There was no indication that where those terms and conditions could be found, and as far as could be established, they were not attached to the quotation. You will note that I have included the clause as set out in the FST's terms and conditions on the slide. Later in April, Dana issued FST a letter of intent referring to purchase of parts as detailed in your quotation. The letter of intent stated that all costs, payment terms will be all agreed between Dana prior to purchase order placement. In June 2003, Dana issued a purchase order with pre-printed terms and conditions on the back. There was a requirement that FST should sign and return within 7 days, but there was no evidence that they had done so. Some years later, there was a new program which required Dana to order more seals from FST and also the supply of seals for new vehicle models. As part of that program, a 2012 purchase order was issued, which was stated as being subject to Dana's 2011 terms. The following year, there was a further purchase order in relation to a part which had previously been supplied to Dana Austria and which moving forward was to be transferred to the UK. In the judge's view, the contract was formed on the 2003 Dana terms. His reasoning was as follows. The 2003 quotation was nothing more than an invitation to treat. The FST terms were not attached and there was no indication where they could be found. There was no evidence Dana had seen or had asked for them. The judge did not see how they could have been accepted or incorporated in those circumstances. He agreed with the description of the letter of intent as an interim holding pattern to keep things progressing. Viewed objectively, the 2003 purchase order represented a formal offer to purchase, which was accepted by conduct when FST delivered the seals. In relation to the 2012 purchase order, it made it clear that the 2011 Dana terms applied. The judge found that it amounted to an offer by Dana to contract with FST on the updated terms. FST acknowledged receipt and acknowledged that a new order number would be referenced on all future delivery notes and orders. FST said that there was no contract in 2012 or 2013, and the purchase orders were post-contractual documents which were administrative, but the judge disagreed with that argument. The 2013 purchase orders was for a particular part which had previously been supplied to Dana Austria and was also subject to Dana's 2011 terms. In conclusion, the seals in question were provided under the 2012-13 purchase orders, which were subject to the 2011 Dana terms. There was no pre-existing contract on FST's terms, and the pre-existing condition was also on Dana's terms. English law therefore applied, and FST was not able to rely on the limitation clause in its terms and conditions. So we've got two cases in which the terms and conditions both contained fairly similar clauses, which appear to have been drafted with a view to win the battle of the forms. In one case, the first shot was victorious, and in the second, the last shot prevailed. All cases will ultimately run on their facts, but it's important to understand that the judge will be looking at the position from an objective standpoint. It's no use drafting the most amazing terms and conditions if they do not end up being incorporated. If you do want to be in the best position to argue that they have been, you need to think about your business usual processes. For example, do you attach your terms and conditions to quotations and purchase orders? It is not always necessary to do so, as terms and conditions can, in appropriate circumstances, be incorporated by reference. But if you are seeking to do that, make sure it is clear where they can be found. Paper trails, or probably more accurately, email or electronic document trails, are always important. Who keeps track of what is sent out or received back, and make sure it is stored where it can be easily located if needed. What is usually signed as part of your usual purchase, sales processes, and who is responsible for signing? Does that person know where to flag something, to check whether it should be signed, for example, like the Panasonic customer file? which might be received before any orders are placed and which may seem insignificant at the time. Next up is Blue Sky Solutions v B Caring. This case concerned a contract for connection of 800 mobile phones for a minimum period of 48 months for a monthly rental of $9,600. The claimant's claim was that the contract was entered on the basis of its order form, which incorporated its terms and conditions. These terms and conditions provided for an administration charge of $225 in the event of cancellation before connection. The defendant did cancel before connection, and the claim was therefore for £180,000, being $800 charges of £225. As can be seen on the slide, the defendant challenged the claim on various grounds. There was no binding contract, there was no incorporation of the terms and conditions, there was no incorporation of the clause providing for the administration charge because it was an unusual or onerous term. It was a penalty clause and was therefore void. There was also no loss to the claimant arising from the cancellation of the order. It is interesting to note the judge's comments on the evidence given by the claimant's managing director, who is described as every inch the salesman, and whose evidence was not accepted unless corroborated. The defendant had an existing mobile contract with O2 through a company called Barclays Communications. They were looking for other options, and they were cold called by the claimant. Following various discussions and a meeting, the claimant sent an email to the defendant saying that an order form would be signed via e-sign. The order form stated all orders and contracts are subject to and incorporate our standard terms and conditions. By signing this document, I agree that I've logged onto the Blue Sky website, have read, agree, and fully understand all terms and conditions, and I'm bound by the same. In fact, the recipient of the email at B Caring did not read the terms and conditions on the website, but forwarded the email to the CEO who signed the order. The terms and conditions were just over a page of detailed text in closely spaced type with no clause heading. In the judge's view, they were not in any way user-friendly. Clause 4.6, which I've set out on the screen, provided for the administration charge. The defendant emailed the claimant saying it was cancelling the order to ensure the organisation fully understood all the particulars of any contract before signing it. The claimant issued the administration charge invoice and then issued proceedings when it was not paid. The judge addressed various different issues. Firstly, was there a contract? The defendant tried to argue that the signature on the order form was essentially a preliminary stage to entering into a contract with EE. The judge found that looked at objectively, by signing the order, they were accepting that they were entering into a contractual relationship with the claimant and that specific terms and conditions applied to it. The next question was whether the terms and conditions were incorporated. Both parties referred to the Impler Warehousing and Logistics Shanghai Company Limited, the Wanjiang Resources Singapore Pte Limited, for propositions that reference to a website may be sufficient to incorporate terms and conditions, whereas there is more than one set of terms and conditions on a website. The terms and conditions relied on must be those clearly applicable to the contract. There were two sets of terms and conditions in this case on the website, terms and conditions for mobile and terms and conditions for landline. The judge found that it would have been reasonably clear which applied here. The next question was whether clause 4.6 and another clause which the judge did not consider was relevant were unusual and onerous terms. The judge considered the principle from the 2018 case of Good Life Foods v. Hall Fire Protection, in which Lord Justice Coulson said, "It is a well-established principle of common law that even if A knows there are standard conditions provided as part of B's tender, a condition which is particularly onerous or unusual will not be incorporated into a contract unless it has been fairly and reasonably brought to A's attention." Following consideration of case law dealing with the difference between a clause in a signed contract and a clause incorporated by reference, the judge said, "If this principle is all about the incorporation and the adequacy of notice, then it is reasonably straightforward to understand why a term included in a signed contract will have been adequately brought to the signing party's notice in all but extreme cases. Where, however, the signed contract simply incorporates by reference terms and conditions, one of which is unusually onerous, It is difficult to see why, as a matter of principle, the same extremely restrictive approach should follow, unless the signed terms and conditions itself drew attention to the unduly onerous clause. So having seemed to have failed at the first few hurdles, there was finally a glimmer of hope for the defendant. Although the judge did not find the clause to be unusual, in this particular industry, he did find it to be an onerous clause because the amount of the cost had no relationship to any actual administration costs. Even if it was disguised entitlement to a loss of profit, it was out of proportion to any reasonable estimate of cost. Even if it was not unusual, the fact that others in the industry might use onerous clauses did not bear much weight. The judge found that the term was not properly drawn to the defendant's attention because the claimant made no real attempt to comply with a code of practice subscribed by a number of network service providers that required, amongst other things, a clear statement of early termination charges. The defendant was not told and had no reason to expect a substantial liability if it did not enter into a contract for the phones. The order form obfuscated the nature of the contract. It was not surprising the defendant thought that it was a precursor to contract with EE rather than the contract with the claimant with a substantial cancellation charge. The order form didn't explain the purpose of the terms and conditions or give any warning about the obligations in the relevant cancellation. The terms and conditions could have been included as part of the order form rather than simply referring to the website. The defendant could have seen how long and complex they were. There was more chance they would have been read. The terms and conditions should have been sent with a prominent heading that they impose financial penalties if the contract was not entered into with the network service provider. No attempt was made to highlight the relevant clauses, which were buried in a section headed cancellation and returns policy. The offending clause itself was described as being cunningly concealed in the middle of a dense thicket, which none but the most dedicated could have been expected to discover and extricate. The judge was not particularly impressed by the evidence given about the terms and conditions as they appeared on the website at the relevant time. If you do seek to incorporate terms and conditions by reference to a website, then make sure there is a clear way to demonstrate after the event which terms and conditions were available on the website at any given time. It's important to be able to produce evidence of what the terms and conditions look like on the web page when accessed by the user. Consider whether it's appropriate to incorporate terms by reference to a website. If it is, otherwise easy to include them as part of an order form. In light of this case, it may be easier to argue that a term has been brought to the customer's attention if they have been provided with a copy of the terms and conditions rather than just incorporating them by reference. If you are seeking to include them, what might possibly be argued to be unusual or onerous terms, then consider how these may be highlighted to the customer, both in terms of how they appear on the page, such as font size, use bold text, including headings, but also whether they should be flagged in advance as part of any commercial discussions. In our next case of Stonard v. Green Shoots Capital, the question the court had to determine here was whether the parties were bound by the terms of a retrocession schedule referred to but not attached to an agreement. There's a dispute related to an agreement by which the claimant was to promote investments in alternative investment products to institutional investors. If she successfully introduced investors, then the investment managers paid her a commission on a retrocession to Green Shoots, who would in turn pay a share to the claimant. The basis on which the claimant was to be paid and whether that was a specific percentage, and if so, what amounts were in dispute. The judgment is following a preliminary trial to determine the basis of remuneration. For today's purpose, we are only focusing on the question the court addressed, which was whether the parties were bound by the terms of the retrocession schedule. There was a draft agreement between the claimant and the defendant, which stated these terms and conditions should be read in conjunction with Green Shoots' most recent retrocession schedule, a copy of which is available to you upon written request. The schedule was not provided with the agreement and was not provided until sometime later when the relationship had already become strained. It was emailed by the defendants to the claimant with the following. I also added the retrocession schedule, which is part of the overall agreement as stated therein. As far as my records go, I believe we never officially submitted a schedule, but since this is the only valid form of confirming terms as per the agreement, I wanted to do that now to have a valid one reflecting status quo until further notice. During the course of the statements of case, it became apparent that it wasn't the case, as initially suggested, that the schedule existed at the time of the agreement was originally sent to the claimant, and that it had simply not asked for a copy. Instead, it was admitted by the defendant that it had only been created a day or two before being sent. In short, there was no retrocession schedule in existence, and that could have been provided to the claimant at her request. The judge found that until such time as a retrocession schedule was drawn up, the fee remuneration was to be based on what had been discussed and already agreed between the parties. The claimant was not agreeing to the defendant creating a schedule and applying a different fee split with retrospective effect. Greenshoot argued that there was no reason why a separate document could not be incorporated by reference and submitted that it was irrelevant that the schedule did not exist at the time the agreement was sent to the claimant. The judge said that it may be possible that parties could be bound by terms which did not exist, but here he looked at what parties were objectively agreeing. The reference to the schedules were in the present tense. In relation to the wording, available on request, if the schedule did not exist, it could not be available on request. The agreement stated that the retrocession schedule contained a number of provisions. That was the language of a document which exists. There was other wording which also contemplated a document that existed and not to be created in the future. It would require very clear language if the parties were actually agreeing to such an unusual provision. The parties were therefore not bound by the schedule because the agreement contemplated an existing document that did not exist. The parties already agreed a fee-sharing agreement that applied at least until such time as the schedule was created. So what is the lesson to be learned from this case? It may sound a bit flippant to say, but make sure you remember to ensure your schedules are drafted when you're referring to them. It's surprising how often similar issues arise. It's more likely to occur when one part of the business is responsible for drafting the front end of the contract, and the other part of the business is responsible for putting together the schedule or schedules, and someone else is then responsible for communicating with the customer. Over to you, Rowan.
Thank you, Sophie. So my next case that I'm going to deal with is a little short one, but with an important point to make. So Onerous and Resifarm was another trial of a preliminary issue, this time on the construction of a clause. The case itself was a claim by Onerous for damages for loss of profits and costs arising from Resifarm's alleged failure to form a manufacturing agreement. The manufacturing agreement concerned a product called Estrace, which was used to treat the symptoms of the menopause. Resifarm stopped supplying to Onerous and the manufacturing licence was suspended. Resifarm gave 2 years' notice to terminate the agreement, but accepted that it failed to supply Estrace for in excess of 2 years, but it denied that it was in breach of contract. Resifarm also argued that clause 9.3 of the agreement, which I've set out on the slide, excluded the claim for loss of profits and costs which was being brought. Resifarm argued that the wording of this clause was clear and it didn't bear any alternative meaning. But Onerous said that if the clause had that meaning, then it would allow Resifarm effectively to choose to walk away from its obligations without performing, and the only sanction available for it would be a claim for loss of profits. That claim would be taken away by clause 9.3, and that outcome would not be consistent with business common sense. Looking at this clause in isolation, you may be inclined to agree with Resifarm. However, the problem here was that the clause appeared as a subclause within a long clause dealing with, amongst other things, indemnities related to third-party claims and obtaining product liability insurance. The judge considered whether the clause should be looked at just as a subclause by itself, as I set it out on the slide, or as part of the clause as a whole in the context of its position in the agreement. When looked at as a subclause by itself, the judge found that it did produce the remarkable outcome that he concluded could not be the meaning objectively intended by the parties in commercial terms. However, when he looked at it as part of the overall context of clause 9, it did produce a sensible result. The judge therefore concluded that the clause did not have the application for which Resifarm contended and was therefore not applicable to the claim being brought in the present proceedings. The judge did note, though, that the contract and the clause were very much a one-off and the drafting was open to some forensic criticism. He was therefore not surprised that it had caused a dispute between the parties. The main point to note from this is that even though the judge considered the clause as a one-off, It highlights the need for clear drafting, not just of each subclause, but thinking about how that subclause might actually be construed if it's read in the wider context of the clause in which it appears. Here, the judge accepted that the language of the subclause itself was plain, but when considered in the context of the remainder of the clause in which it was appeared, it was found in favour of the claimants that it was to be their case. The next case that I'm going to look at is CIS General Insurance and IBM, which was a case in which IBM contracted with Co-op for the implementation of a new IT system and the management of that system for 10 years. IBM subcontracted the supply of the software to a third party, and there were issues which resulted in IBM missing important milestones. IBM issued an invoice in respect of a later milestone, which CIS refused to pay as it said the payment was not due. IBM purported to exercise the right to terminate in respect of the non-payment. CIS then argued that IBM did not have a right to terminate as the payment was not properly due, and that IBM was therefore a repudiatory breach of contract, which it purported to accept. CIS brought a claim for damages, which included a claim for some £128 million in respect of wasted expenditure from IBM's alleged wrongful termination. The court decided that IBM was not entitled to exercise its right to terminate and was therefore in breach of contract. Now, the judgment runs some 175 pages, so I'm not going to attempt to provide you with a summary of all of the case. But for today's purposes, I'm just going to focus on the question of whether CIS was entitled to succeed in its claim for wasted expenditure, or whether it's excluded by the contractual terms. IBM relied on the clause that I've set out on my screen. Subject to clause 23 and 23.4, neither party should be liable to the other, and then we jump forward to loss of profit, revenue, and savings, which is the key part that I've highlighted in bold there. IBM argued that although CIS's claim was framed as a wasted expenditure claim, when it was analysed, it was actually a claim for loss of profit. And although calculated by reference to expenditure incurred, the actual loss was profit, revenue, or saving that would have been earned by that expenditure if the contract had not been breached. CIS argued that a claim for wasted expenditure was not a loss of profit claim and therefore should not be excluded by this clause, but the court disagreed. Mrs. Justice O'Farrell said the starting point was to look at the contractual benefit that had been lost as a result of IBM's repudiatory breach of contract. Here, the loss of bargain was the savings, revenue, and profit that would have been achieved by CIS by having an IT system that was anticipated to increase its business competitiveness and to produce substantial savings, increased revenues, and increased profits. A claim for damages of this nature can either be framed as reliance loss, which is the expenditure incurred in reliance on the defendant's promise, or it can be framed as expectation loss, which is the financial value of the expected contractual benefits, such as lost profits. CIS had advanced its claim as reliance loss, but Mrs. Justice O'Farrell said that did not change the characteristic of the losses for which compensation was sought. It was simply a different method of quantifying the loss of the bargain. She therefore found that the claim was excluded by the clause in question, whether it was quantified as lost profit, revenue, and savings, or whether it was wasted expenditure. She also commented on the case of Royal Devon and Exeter NHS Foundation Trust and Atos, in which a wasted costs claim was allowed by the court, even though there was a similar exclusion clause. But she distinguished that case on the basis that the benefit lost in that case was not a financial gain. So the point to note here is that clauses excluding loss of profits are commonplace in IT and other commercial contracts. The circumstances of this case, in which the ultimate benefit for the party purchasing the software or services is going to be profit related, is likely to be mirrored in many such projects. And whether that is going to be a good thing for you or not is really going to depend on which side of the contract you're sitting. As always, these cases are going to turn on their particular facts and the wording of the clause in question. But in light of this case, there's likely to be a renewed focus on the drafting of such clauses. And you need to think about your individual position and whether a clause phrased in a similar way is going to be of value to you, or is going to result in you potentially being extremely restricted in the losses that you might be able to recover in the event of there being a breach of contract. My next case is Equitix and Fox. Another very little short summary here. The relevant point in this case arises in a supplemental judgment dealing with a discrete point of part of consequential orders following judgment. And this was a claim for breach of warranties in a share sale agreement. I don't need to go into the background of the claim, other than to let you know that the result of it was a judgment for £11 million. The defendants argued that a limitation of liability clause in the agreement limited the aggregate claim to £11 million, including not just the damages, but also the interest on costs, Part 36 uplift, etc. A claim was defined under the agreement as any claim under this agreement for breach of warranties, and the cap applied to liability in respect of the relevant breach of warranty claims. Equitix argued that ancillary orders such as the payment of costs and interests were not liable in respect of were not liabilities in respect of the claim. And the judge stated that whilst it was permissible for parties to provide for specific costs or other ancillary consequences of a breach of contract, the defendant's construction here was not right. The use of the words in respect of, whilst wide, meant that it was claims in respect of a claim under the agreement. Interests and costs, etc., were not claims under the agreement, but were pursuant to the court's jurisdiction. The judge also agreed that the wording in respect of was not as wide as the wording that's often used of arising out of or in connection with, and there was no specific mention of interest or costs in the contract clause in question, which one would expect to see if such important rights were being given up as part of that clause. So the learning point here is to consider what you actually want to include in your limitation of liability claim clause. If you want everything to be the subject to the cap, including interest and costs, then make that very clear and use specific wording to that effect. Also be alive to the different consequences that may result from using the wording in respect of rather than arising out of or in connection with. Now, in some cases, you might want your clause to be very narrowly construed, but consider the point carefully because that may not always be the position, and you might find yourself with different outcomes depending on which wording you use. Now, my next case is one in which the Supreme Court grappled with the question of whether an employer can claim for liquidated damages for delay if the contractor does not complete its work and the employer never accepts it. Now, although liquidated damages clauses are a regular feature in construction projects, this is actually a case dealing with a software implementation project. By way of background, TriplePoint contracted to customize its software for commodity trading and risk management for PTT. Payment was to be made under the contract by reference to milestones, but the work on phase 1 was delayed and TriplePoint only completed stages 1 and 2 of that phase, which it was 149 days late in delivering. TriplePoint demanded payment in respect of other invoices which it submitted, but PTT refused to pay on the basis that the invoices were not due under the contract. TriplePoint therefore refused to perform further without payment, and PTT gave notice to terminate. TriplePoint issued proceedings for its unpaid fees, and PTT counterclaimed for various damages for breach of contract on termination, which included liquidated damages up to the date of termination. TriplePoint denied liability. There are various other arguments that I won't cover today, and I'm going to focus solely on the question of the liquidated damages. Now, the services under the contract were to be performed in accordance with the project plan, and it provided that if the work was not delivered within the time specified and the delay had not been introduced by PTT, then TriplePoint was obliged to pay liquidated damages. I've set out the clause on the screen, and as you'll see, there's key wording on the end which refers to acceptance of the work. TriplePoint argued that the liquidated damages were therefore only payable for the 149 days of delay in completing stages 1 and 2 of phase 1, claiming that was the only work which had been completed and accepted. And so it was only liable to pay liquidated damages of some $150,000 odd US dollars. But PTT argued that the liquidated damages were also payable for the delay in delivering all uncompleted work up to the date of termination, resulting in a claim for liquidated damages of over $3 million US dollars. At first instance, the judge found the delay to the project had been caused by TriplePoint's breaches of various contractual obligations, and they were therefore held to be prima facie entitled. PTT was therefore held to be prima facie entitled to damages. Those included liquidated damages for delay, which were to be calculated from the specified completion dates for both phase 1 and phase 2 up to the date of termination of the contract, with unliquidated damages recoverable from that point. TriplePoint appealed and PTT cross-appealed, and Lord Justice Jackson reviewed the previous authorities and concluded that there had been alternative conflicting ways in which the court had previously addressed the question of liquidated damages when works had not been completed. These were that the liquidated damages weren't available if the works were not completed before termination, and instead there was a general damages claim that could be brought, subject to any exclusions or limitations in the contract. Liquidated damages could apply for delay until termination, with general damages available thereafter, subject to any relevant exclusions or limitations. Or alternatively, liquidated damages could apply post-termination until the works were completed by an alternative contractor. He reviewed these different approaches, and it was the second of these analyses that had been previously described as the orthodox approach. However, Lord Justice Jackson considered that whether the liquidated damages would cease to apply altogether or continue up to termination or beyond depended on the particular wording of the clause. And in this case, the clause referred to delay between contractual completion date and the acceptance of the work. The Court of Appeal therefore found that PTT was only entitled to liquidated damages for phase 1 works that had been completed and accepted, and not the remaining works which had not been completed as at the date of termination. For those phases, PTT had to claim unliquidated damages for the delay. Now, this was a step away from the orthodox approach, and it caused some disruption until the case found its way to the Supreme Court earlier this year, when Lady Arden described the Court of Appeal's previous summary of the issue as a radical reinterpretation of the law relating to liquidated damages and inconsistent with commercial reality. She commented that liquidated damages are supposed to be a predictable and certain remedy, and that parties must be taken to know that their entitlement will end on termination of the contract. After that point, the parties may seek damages for breach of contract under the general law. Lady Arden said that the true construction of the liquidated damages clause were that damages were payable in the event that Triple Point did not complete the works on time, irrespective of whether PTT accepted any of the works which were completed. To conclude that there would be no liquidated damages if there was no acceptance of the completed works would render the clause of little value in a commercial context, and she described the Court of Appeal's interpretation as being throwing the baby out with the bathwater. Lord Leggett added additional reason for allowing the appeal, stating that it is ordinarily to be expected that unless the clause clearly provides otherwise, a liquidated damages clause will apply to any period of delay in completing the work up to, but not beyond the date of termination of contract. So after the shift in direction by the Court of Appeal, the Supreme Court's decision restores the clarity around liquidated damages claim, where a contract is terminated before the work is completed. Subject to the particular contract wording, if a right to liquidated damages has already arisen, that right will usually be preserved on termination. The liquidated damages will be calculated up to the termination date, and beyond that point, it will usually be open to the employer to claim unliquidated damage for delay, assessed in accordance with usual principles, but subject to any limitations or exclusions that might otherwise be in the contract. So the key point from this case may sound obvious, but it's to think carefully about what you want your liquidated damages clause to achieve if there is likely to be delay. If you want the position to be something other than the orthodox approach set out by the Supreme Court, i.e. you want your liquidated damages to fall away altogether in the event of there being termination before completion, or if you want liquidated damages to continue all the way up until completion by another contractor, then you need to word your clause very clearly and very carefully. And so perhaps appropriately, I'm going to finish our session dealing with a case on termination. This is a case of Digital Capital and Genesis Mining Iceland. And the number of the dispute was an agreement between the claimant and the defendant by which the claimant was to provide certain regulatory and software services. Excuse me. The claimant brought proceedings primarily for unpaid invoices, but the defendant alleged that the claimant was in repudiatory breach of contract and that it was entitled to accept that breach and recover payments already made on the ground of total failure of consideration. The claimant denied breach and alleged that the purported termination was itself a repudiatory breach which it accepted. There's a long and detailed chronology of events in the judgment that I won't go into detail, but I'm just going to focus on the issue before the judge in relation to termination. And the reason for addressing that issue particularly today, as it touched on a tricky topic, which is that of contractual versus common law rights to terminate for repudiatory breach. The agreement question contained the clause which I've put on the slide, which is seen in very similar terms in many contracts, which is essentially a right to terminate in respect of breaches, but with an opportunity to try to cure that breach. The clause went on into 16.5 to state that the right to terminate will without prejudice to any other right or remedy. Both parties here accepted that all the breaches relied on by the defendant were material and all in principle were remediable. However, the defendant argued that the claimant's breaches were so serious that they were not just material, but they were also repudiatory. The defendant therefore argued that it had an independent right to terminate a common law which was not circumscribed by the termination clause and the requirement to give notice in 16.1. It was not in dispute that no notice to remedy had ever been given. Here the judge said that on the face of it, the clause applied to any material breach, whether repudiatory or not. If clause 16.1 was looked at in isolation, then the judge said it would have been distinctly arguable that remedial material breaches would only be treated as repudiatory if they were not remedied within 30 days. That construction did not exclude the common law right to terminate for repudiatory breach, but it simply defined the circumstances and the conduct that was required to trigger that right. However, when looking at the contract as a whole, the judge stated that the common law right was not circumscribed by clause 16.1 because clause 16.5 expressly served any other right or remedy in respect to the breach concerned. The judge therefore accepted the defendant's argument that if the claimant had committed breaches of contract which were independently repudiatory, i.e. not just material, then clause 16.1 could be ignored and the defendant could exercise its common law right to terminate for a repudiatory breach. She went on to consider whether the breaches were in fact repudiatory. As those breaches were fact specific, I won't go into them, but suffice to say, she found although the claimant was in breach, it was not a repudiatory breach of contract. The defendant was therefore not entitled to terminate the agreement as it purported to do and was itself in repudiatory breach of contract. The claimant was therefore entitled to payment of its unpaid invoices, totaling some £2.4 million, and there will be a second trial to assess the claimant's damages as a result of the wrongful repudiation. So finishing up then with our last lessons to learn, the judge stated that the relationship between common law and contractual rights of termination is a question of construction in each case, and there are no hard and fast rules. It makes it extremely difficult to give any hard and fast guidance about what you should do in these circumstances. But the key point to take away is to tread extremely carefully around termination provisions, particularly where you potentially have coexisting contractual and common law rights. You need to weigh in the balance which option is likely to expose you to the lowest risk, as getting it wrong can have significant financial consequences. Also make sure that those on the ground who might be involved in termination seek advice from you before they start taking any steps that might otherwise prejudice your position. So thank you. I'm conscious that we've run a few minutes over our intended timescale, so we won't cover off any questions today, but I hope you found it useful. You have our contact details here on the slide, so if you do have any separate questions that we've not covered, do please feel free to email us. For those of you, I can see we've got a couple of questions on the screen. We will follow up with those for you separately. Thank you very much for joining us. Please do look at our website for our future events that we have coming up. And in the meantime, I hope it's not too early to wish you a very healthy, happy and restful festive season. Thank you very much. Bye-bye.
Thank you.